4 years after 780 and 1269, Oklahoma Court of Criminal Appeals affirms a 10-year sentence for possession of CDS. I'm Tulsa attorney James Worth, and we're talking about another new decision from the Oklahoma Court of Criminal Appeals. It is in F 2019-880. It is not out for publication, and it involves a gentleman who was charged with possession of CDS within 1,000 feet of a school. At the time he was charged, that was a felony. I believe it had up to 12 years in prison or something along those lines. But ultimately, he entered a plea deal to take it into drug court. And in the drug court program, it's a very onerous program, a lot of hoops you got to jump through. It's over generally a 3-year period. Where you try to graduate that program. And if you graduate, you usually get a sweetheart deal, maybe a deferred sentence or maybe dismissal at that point. But if you fail out, then you get a bad plea deal. And that's entered at the time that you plead into drug court. In this case, the agreement was a 10-year sentence if he fails out of drug court. However, while he was in drug court and going through this process, there were some changes under the law. 780, State Question 780 was passed by the people that made the crime that he was originally charged with go from a felony to a misdemeanor with a maximum sentence up to 1 year. And then the legislature passed 1269, which said that for crimes that were previously felony that are now misdemeanors, if there's an application to revoke on probation for a deferred or for a suspended or application to accelerate for a deferred sentence, that the maximum sentence is going to be the new maximum sentence of 1 year. So the court here has to decide, how is that applicable to somebody in drug court? Because ultimately the state alleged that he did not complete drug court after more than 3 years, and they filed a terminator from drug court, and now they're looking to give him that bad sentence of the 10 years for a crime that now has a maximum of 1 year. And in many circumstances, the court has looked at a drug court sentence like a deferred sentence. Because ultimately you enter a plea deal, but you're not sentenced until after it's decided whether you completed drug court or not. So it's very much like a deferred, and a lot of the arguments and how we look at different procedures for drug court go along the deferred. So one would argue it should be treated like a deferred in these circumstances where 1269 makes it clear he cannot be given more than 1 year sentence. Or if it were suspended, could not be given more than a 1 year sentence. However, the Oklahoma Court of Criminal Appeals here decided to find that it is different. That is different than a deferred. Apparently, it's different than a suspended. It's its own beast, and it was left out of 1269. Therefore, we're going to go ahead and give him the full 10 years. So he ended up getting 10 years in this case for what now has a maximum of 1 year under 780, and what it's clear that the intent would be under 1269 passed by the legislature, that he should only have 1 year, and it should have been treated as a deferred, but they made it a separate beast, so they give him the full 10 years. So that's another example of maybe why we have the highest incarceration rate or second highest incarceration rate in the nation and the world. If you've got questions about your case, family, friends case, you're going to want more than this general information. You're going to want specific information confidentially from an attorney in Oklahoma. To get that scheduled, you can go online to makelawEasy.com.